Hi, everyone. This is Halley Auger from the Calgary office of Samfiru Tumarkin, here from cold Alberta. Hopefully, we're coming to the end of this winter storm. I have my Valentine's Day sweater on. I don't know if you can see Bubbles back there. Bubbles has her Valentine's Day bow tie on as well. And so last time I was here, it was right before the Christmas break. I had my ugly Christmas sweater. Bubbles had her not so ugly Christmas sweater, but today we're dressed for Valentine's Day. So as the questions roll in, I want to talk about something that's made it to the news in employment law, and that is that Meta, the company that has Facebook, has decided to do performance-based layoffs. And so I want to chat a little bit about what would be required for a performance-based layoff in Alberta. Certainly, as a non-unionized employee, your employer is allowed to terminate you at any time for any reason, whether you are a exceeds expectations or a falls below expectations employee. Your entitlement is the same. It's notice or pay in lieu of notice. When there are performance concerns and the employer is trying to terminate for just cause, it's notoriously difficult for them to do it. So the reason for that is, in order to terminate an employee for poor performance, the employer would need to set out what the standard of performance is. And they would have to have a court understand that. And that can be very hard for a court to assess what is competence, what is meeting those employment standards, because that has to be established before the employer can say that this employee fell below them. Beyond that, when a termination is trying to be for performance, particularly a just cause termination, the employer has to show that they've set what the standards are, they've communicated those standards to the employee, they've provided that employee with the opportunity to meet those standards and warned them that if they didn't meet those standards, they could face further disciplinary action up to and including dismissal for cause. So if you've been terminated and it's for cause and it's an allegation that it's performance-based, certainly reach out to us at employmentlawyer.ca. You can email us also at help@employmentlawyer.ca. Just cause cases are very hard for employers to prove, and so the scale is usually tipped in the favor of the employee, and so you may have a very good case for severance. All right, let's turn to some of the questions. Question from Brief Awareness. My boyfriend works for a smaller IT company. Today, they sent out a letter to all employees stating that they will be closing the business in 2 days and that everyone's employment would end as well. In a meeting the higher ups held, someone asked about severance pay. The meeting was being held virtually, and the CFO said that the company can't pay severance to their employees, that the company is not going to file for bankruptcy because that would cost money and they don't want to spend it right now. Is this legal? Great question, Brief Awareness. Certainly we understand companies have financial difficulties. Your boyfriend's company undoubtedly knew that there was financial difficulties well in advance of the notice that they provided to the employees. An employer has to behave responsibly towards its employees. So an employer can shut down its doors, but they still are required to provide at least the minimum notice or pay in lieu of notice or termination pay under Employment Standards Code. So that's based on length of service only. At a minimum, if you've been working at an employer for more than 90 days, you're entitled to 1 week. It goes all the way up to 8 weeks, and it's based on length of service only. So for an employer to give 2 days notice, that's less than the minimum standards, and that would be illegal. Even in a bankruptcy, and certainly even on an insolvency, which is when a company can't pay its liabilities as they become due, and a company is still on the hook to pay termination pay if they're providing only 2 days notice. In fact, even the directors can be personally liable for termination pay. So It doesn't sound like it's going to be a situation where these employees are going to be able to get anything more than their bare minimums, because just the minimum employment standards code pay is protected. So your boyfriend should be calling employment standards because they can help him navigate filing a claim for termination pay, as well as any other outstanding pay, like outstanding wages, outstanding vacation pay. With respect to anything over and above the minimums are just that, mandatory minimum. They set a basement, not a ceiling. The chances of being able to recover anything over and above that would be difficult if the company truly is insolvent. I mean, you can't get blood from a stone. So he is likely to be able to get his mandatory minimums. I don't know how long your boyfriend has been with the company, but I'm assuming it's longer than 90 days, which means he's entitled to at least 1 week's notice or pay in lieu of that notice, okay? All right, question from Rick. I've been with this company for 15 years. I started as a machine operator, worked my way up to maintenance supervisor, and then got signed up for electrical apprenticeship. I've spent most of my life there on night shifts. Last year, I took a voluntary demotion from supervisor to just apprentice electrician to go to day shift and finish trade school. I've now received a letter informing me I'm being sent back to permanent night shift, and if I don't pass the C of Q by August, I'm assuming that that's a certification of qualification. By August, I will be demoted to my original position of operator. Can they do this? Well, it sounds like you were on a voluntary temporary demotion. And so you and your employer have agreed that for a temporary period of time, you would move from the night supervisor position to a day position solely for the reason that you can finish trade school. And in that period of time, still get your income by having day shift. So in this circumstance, it sounds like you and your employer have agreed that there was a temporary duration of you being moved onto the day shift. So it also sounds like your employer is giving pretty significant notice. I mean, we're in February and they're giving notice that you would have to go back in August. So they are giving you time to finish your C of Q, I think you've called it. Now, they can't demote you back to your original position of operator because they haven't done that with your agreement. Either you stay as, well, I suppose, you know, if you can't do the apprentice electrician role, if you're not in trade school, I'm not really sure about that, then they have to do something with you. They can either put you back to your previous role, or they're saying that if you want to stay on days, you want to be operator. It's really difficult to say if that's a constructive dismissal in these very, very limited and narrow circumstances. Figuring out if somebody is constructively dismissed is an individualistic exercise. And so not all circumstances of an employer changing the employment relationship results in a constructive dismissal case. Normally, employers can't substantially and fundamentally change terms of your employment relationship without your consent. But in this case, it sounds like there's a little bit of consent in order to do this. So if you want to speak with an employment lawyer, we're certainly happy to. Please reach out to the firm. You can find us at employmentlawyer.ca, and then we can have somebody sit with you and really assess the individual factors of your case and about whether there was a temporary duration of this agreement or not. You know, understanding that, you know, it may be implied that this was a temporary duration just for the period of time for you to get your trade ticket. All right, back to questions from the audience. I've been working at one of the top banks in Canada, and every time I ask to see my contract, they dodge the question. It's been about 6 months and still nothing. Recently, they've taken a mean turn and are seemingly trying to frustrate me out of the position. My managers berate me, and when I asked for my contract, she said, and I quote, "You can leave if you like, you can quit anytime. Can I please get any legal advice as I'm about to quit this job?" All right. Well, I'm sorry, effective cover, that you're going through this. It does sound like an inappropriate comment from your manager. Let's chat about the first part of your question, and that is, does your employer have to provide you your employment contract? One would think, obviously, yes, they would. What I will say is employment contracts generally protect the employer. They're not there to protect the employee. Employment contracts tend to limit somebody's rights. Because if somebody doesn't have an employment contract, the rights that they have are the default rights. And the default rights are often and usually much greater than what contractual rights are. So why an employer wouldn't want to provide you the employment contract that probably limits your rights is surprising. Regardless, you can actually make a freedom of information request and get your contract that way. It's ridiculous that it comes to this, but you can make what we call it a FOIP request for your employment agreement. Usually it takes a little while. You may also try and, instead of just asking your manager, asking HR. Now let's chat about the second part of your question, and that's the employer trying to frustrate you out of the position and saying you can leave if you like, you can quit anytime. Now, you've said that you work at one of the top banks in Canada. So what I'm assuming is that it's one of the federally regulated banks. The big banks, the big ones, and I won't name them, are usually federally regulated. So what that means is, instead of your employment being governed by the Provincial Employment Standards Code, it's governed by the Federal Canada Labor Code. And even though you're not a unionized employee, you still have enhanced protections. And one of those protections is that you cannot be unjustly dismissed. So while normally an employer can terminate you, and provide you with notice or pay in lieu of notice, federally regulated employers can only terminate you for 4 or 5 reasons. It's discontinuance of function, they're shutting down the business, they're doing mass layoffs, or they are terminating you for just cause. And so federally regulated employers sometimes can't terminate somebody that they really would like to, because they risk a Canada Labor Code complaint. So sometimes, unfortunately, we do see federally regulated employers try and push people out, to push them to quit because they don't have the ability to just let them go without cause. We also, unfortunately, see some federally regulated employers make allegations of just cause to try and get somebody out, because that's one of the reasons. So effective cover, you may want to reach out to our firm and speak with one of our employment lawyers to talk about whether you may be in a situation of your employer trying to push you out because they're not really allowed to just terminate you and pay you some severance. All right, question from Ryan. I work in a warehouse and drive mostly a forklift/receive pallet into the system. My boss asked me to train another department's process path to help. This would require me to train on a machine that would elevate me above 40 feet. I initially agreed, but during training, I realized that I have a fear of heights and was not able to complete the training. My employer said that if I don't complete the training, that I would be suspended without pay and that I would need to apply for accommodations, which would take up to 2 to 3 weeks to process. Can they do this? Interesting question. So, an employer certainly is allowed to delegate and assign tasks to somebody and to organize their workforce if they want you doing some additional tasks or some different tasks. Normally, they'd be allowed to do that. Now, the question is your fear of heights, does it give rise to enhanced protections under human rights legislation? Under human rights legislation, if there are aspects of your job that you can't perform because you're a member of a protected class, whether that's a religious reason, a disability reason, certain things, then your employer has to accommodate your disability to the point of undue hardship. So the question is whether the fear of heights rises to the level of a disabling condition. And so that would require you to get medical evidence, whether it would be a mental or a physical limitation, I'm not sure, but to speak with your doctor about the fact that your fear of heights is actually part of a medical condition and that it prevents you from doing your work. I'm not sure. To be honest, I don't know the answer to that. There are people who can't go to heights because they do have, recognized medical conditions, whether it's vertigo or, blood pressure issues. And so that would be a medical condition for which the employee needs an accommodation and the employer has to accommodate to the point of undue hardship. When an employee says that they can't perform certain aspects of their job and it's because of a medical condition, the employer is allowed to require medical information. Now, they're not entitled to know a specific diagnosis. That's certainly private information, but they are allowed to know what the limits are as a result of the condition. For example, accommodation. So in this case, you're saying, I have a medical condition. As a result, I have, symptoms and I can't be up 40 feet in the air doing it. But that wouldn't be something for you to say. It would be something for your doctor to be able to document and to provide to your employer. Short of that, I don't know I don't think your employer can terminate you for just cause. They would have to say that that's insubordination. But in my view, it's probably excusable insubordination, particularly if you're saying I'm refusing work because it's a safety issue, even if it's not a medical condition. For me, my fear of heights means that I freeze, I paralyze, I can get stuck up there and I won't be able to get down. So it could still be a safety issue and you're refusing work on the basis of a safety issue versus a human rights issue. So it'd be pretty hard for your employer to terminate you for just cause on that basis. That's not to say they can't terminate you if it's not a medical condition that for which you're seeking accommodations. They could still terminate you and provide you with notice or pay in lieu of notice. All right, question from Dusty. My wife, 37, got laid off today after being employed for about 8.5 months as a receptionist. Her termination letter stated she was let go without cause and she was offered 1 week of pay. Her annual earnings would have been $40,000. Does her severance amount seem to be correct? Great question, Dusty. I'm sorry to hear that about your wife's layoff. It's never easy to get laid off. Her termination is without cause. So nobody is suggesting that she's committed any misconduct here. It simply sounds like it was a straightforward case, and the only issue is whether your wife is entitled to more notice or pay in lieu of notice. The 1 week's pay that they've provided is the Employment Standards Code minimum. Whether your wife is entitled to more depends on a few factors. Does she have an employment agreement that says that if she's terminated, all she's entitled to is 1 week's pay and nothing more? Or more aptly, all she's entitled to is Employment Standards Code pay and nothing more? So you'd have to take a look and see if that's enforceable language. A lawyer can certainly do that for you. The other question is, if she doesn't have an enforceable term in her employment agreement and she's entitled to notice in accordance with the default rules, we call those the common law rules, your wife is entitled to notice in accordance with her age, her length of service, the character of her employment, and the availability of comparable jobs in the marketplace. 37 years old, great age. It's probably not going to prevent her from finding new work. Her length of service is short. So 8.5 months on a resume may not look great to future employers because they may say, well, why did you get let go after 8.5 months? So normally long-serving employees are entitled to more notice or pay in lieu of notice, but the inverse is true for very short service employees. So if you're less than 2 years, and that's simply because on a resume, if somebody says, oh, we only worked 8.5 months, what went wrong? It can mean that you may have a harder time finding new work. Now, in terms of character of employment, as a receptionist, that's a highly transferable skill set. It means that there's a lot of jobs out there that she may be qualified for. If she's earning about 40,000, that's pretty much in line with fair market value. She should be able to find a new job that pays, in that range. And the question is how long it would take her. Given the transferability of her skills, she may not be entitled to a lot more notice. Certainly, if you'd like to be assessed on an individual basis, reach out to us at help@employmentlawyer.ca. We also have a severance calculator on our website that she should take a look at. All right, question from Saga World Boss. If I leave my workplace, does my workplace have to pay me out for my unused sick hours? Normally, no. Sick time is different than vacation time. Vacation time is calculated as a percentage of earnings. So if you are entitled to 2 weeks vacation, that's 4% of earnings. If you're entitled to 3 weeks vacation, that's 6% of earnings, and so on and so on and so on. Sick hours aren't the same. So sick hours usually aren't a percentage. Employees may get, 3 sick days or 5 sick days a year, but if you don't use them, they don't tend to roll over. So unlike vacation pay, which cannot be use it or lose it, sick days can be use it or lose it. So essentially you get a maximum of number of sick days that you can take while getting paid. If you don't lose them, there's no monetary value that they convert to. Vacation pay is different. Use it or lose it policies are illegal. Employers have to provide the opportunity to an employee to use their vacation pay or vacation time. If they don't use all their vacation time, it has to get paid out. Either they're going to let it roll over. They don't have to let it roll over, but either they do let it roll over, or they cash it out at the end of the year, or they cash it out on termination. Sick days are different. However, I say the caveat, some employment policies actually have in writing that if you don't use your sick days, they do have a cash value and they get paid out. I've only seen it once. I have seen it, so it does exist, but the default position is no. All right, question from Adorable Flounder. My uncle has over 15 years of experience, but took a break from work between 2022 and 2024. Now he's looking for a job to do until he reaches retirement. He secured an interview at a local burger joint. Everything went well, but at the end of the interview, they mentioned that he would need to complete a 2-week training period, working 2 to 3 shifts per week for 3 to 4 hours each. However, they also stated that the entire training period would be unpaid, and only afterward would they decide if he's fit for the job. Can they do this? No. In this circumstance, the training needs to be paid. This is on-the-job training. It's not in a classroom training. This is on-the-job training. I'm assuming it's a burger joint, so he's going to be doing shadow shifts while he first starts for the first couple of weeks. But during that period of time, it's on-the-job training. So he's on the job, so he has to be getting paid for it. So no, unfortunately, that's just it. It's like you think employers know the law out there, but unfortunately they don't. And granted, let's admit, employment law is complicated. It's why lawyers like me exist. It's why not only, we have lawyers that specialize in employment law and do nothing else, because it is a complicated area of law. But we do expect on at least a basic level that employers, do sort of know the basics, and that should be paid work. All right, so it looks like that's all of our questions we have for right now. What I'll do is I'll chat a little bit about the fact that we have Valentine's Day, and as a litigator, unfortunately, we're all pessimists. Nobody comes to me because things are great. People come to me because things aren't great. And so, what more appropriate time to talk about relationships in the workplace than Valentine's Day? So, relationships in the workplace are often discouraged, and particularly they're discouraged when there's an imbalance in power. Certainly, there can be consensual workplace relationships, but at law, the issue really is a relationship truly consensual when it is in a power dynamic. So employers should certainly have policies that set out requirements for disclosure for in office relationships. Those employees are often not permitted to work together. Certainly, they can't be in a managerial and subordinate level. If you are in, everything goes right until it doesn't. And usually it goes wrong when there's a breakup and all of a sudden now we're dealing with power imbalances. If you're an employee and you are in a workplace relationship and it's affecting your work, particularly if you are in a workplace relationship with a manager, please don't hesitate to reach out and to talk about whether you have a case. All right, and it looks like probably our last question, we did get one roll in from John M. I worked for a bank for 3 years and I had a successful run through my time there, got promoted 3 times. After a review, I was dismissed with cause for minor discrepancies in paperwork. I feel this was unjust, as the same discrepancies have been found in several other employees, and it never awarded even disciplinary action. I filed a complaint with the labor program, but I got a reply it would take months to get assigned to a review officer. Is that all I can do? It's a great first step. If the bank you work for is federally regulated, then that's the federal labor program is who you've filed the complaint through. That would be for an unjust dismissal, and you're saying there was no cause to terminate me. The federal labor program can order reinstatement with back pay. Unfortunately, it is backlogged. We're experiencing 12-month delays in getting a review officer assigned. So it's not just you, John. It's a backlogged system. There are things you can do in the meantime. Certainly reach out. Talk to a lawyer, because what you're saying is not just cause. It probably goes back to what we were chatting about earlier. That's employers, federally regulated employers who want to let somebody go. They're not a great fit. Maybe somebody else can do their job for cheaper, but they need to find a reason to terminate them. And it has to be one of the enumerated reasons under the federal legislation. So they make these allegations of just cause. Chances are you're entitled to severance. You can go for reinstatement and back pay if you want to be reinstated, and those amounts can be big, given that you may be off work for at least 12 months because it's taking so long for your claim to be assigned. Regardless, I highly recommend that you reach out to our firm and speak with a lawyer. I don't think it's just cause, and we can see if we can get you some severance. Okay. Now, and certainly we can help review your Canada Labour Code complaint as well to make sure that was done correctly, so that there aren't any extra delays, given that it's already a delayed process. All right, so I think that's it for today. Not a lot of questions, but it's great. So it was so nice to see everyone today. Thanks for asking your questions. We have our lovely Dan Balcaran from our Vancouver office on Valentine's Day. I don't know, maybe we'll convince Dan to wear a little Valentine's Day outfit, maybe a little pink tie or a pink poof. But if you have any further questions, Dan is excellent and he'd be happy to carry on. All right, thanks so much, everyone.